Hello, I'm Professor Ian Fletcher and I'm here to tell you about my course Corporate Insolvency 1, Liquidation and its Consequences, which is numbered as GO90 in the UCL LLM. This is a half-subject course for 15 credits, and all of the classes are delivered during Term 1 by means of 10 two-hour weekly meetings between October and December. The main classes are supplemented by tutorial classes where we break down into smaller groups, and there's also the opportunity to do a practice assessment during the Christmas vacation based upon previous examination questions. This is not counted as part of the course assessment, but you'll be given some feedback and a general awareness about how your performance would measure up under real examination conditions. This is a course which is very attractive to people with an interest in commercial and corporate matters, and it is a subject which has become increasingly in the public eye in recent years. With the major collapses during the global financial crisis and recessions that followed that, more and more headlines have concerned major financial failures of companies and sometimes individuals as well. But it's important to understand that insolvency can happen in good times as well as bad. Companies can overextend themselves or can be let down by the failure of a vital trading partner. And so the insolvency statistics show a regular high incidence even in times of prosperity. So it is very important, particularly if you're going to be in a position of advising parties in business about how to confront crises that they may encounter in the course of their occupation, to be able to understand the full background of corporate insolvency and how the incidence of insolvency is dealt with by the law. This course is therefore a very practical course. It's one which is designed to appeal to people with a practical interest in corporate matters and commercial matters, and it concentrates on the liquidation process rather than rescue of companies. Corporate rescue and the procedures that accompany that are dealt with in a different course, separately taught in Term 2 by my colleague Professor Andrew Wilkinson. That is Corporate Insolvency 2, Financial Restructurings. But my course will show you the worst case scenario where the company either cannot be rescued or has left it too late even to attempt to be rescued. And so we will see week by week what are the steps that take place and how the law deals with the various problems that will inevitably arise. It's not necessary to have a prior knowledge of insolvency law in order to take this course, but it is useful to have some familiarity with company law in general, so that you understand the nature of a company and the different roles and functions of the key players and interested parties, principally the shareholders, the directors, other managers, the employees, and of course the creditors, with whom this course and the law itself are primarily interested. The course is examined in Term 3 by means of an unseen written examination which lasts for 2 hours, and you are able to take permitted materials into the examination. There are various sets of commercially produced materials which are useful and can be taken into the examination, and guidance will be given about the purchase of these during the course of the early classes. We begin the course with a general examination of the meaning and nature of insolvency itself, and we shall see that the law has had to formulate definitions for the purposes of dealing with this phenomenon that we call insolvency. We shall also look in the early weeks at a number of key concepts that will surface again and again throughout the course. These include the basic notion of equality of treatment of creditors and the concept of collectivity which brings all the creditors together into the same pool for legal treatment. However, we shall also find that there are factors which differentiate between different subgroups of creditors, and it's important to understand why and how these differentiations are created by the law. Another key concept is the distribution principle that is called the pari passu principle, in which the property that survives from the company is distributed according to a legal statutory scheme among the participating creditors. Once we've covered the basic ground and looked at some of the historical background of the law's development down to the present day, we'll begin to see how a company which is in financial crisis can be put into liquidation in one of two alternative forms. These are called respectively voluntary liquidation and compulsory liquidation, otherwise known as winding up by the court. Voluntary liquidation, as the name suggests, is initiated by the company itself and doesn't normally involve any active role for the court to play. But in case things go wrong during the course of a voluntary liquidation, the court is in the background and its jurisdiction can be invoked. We'll see the circumstances in which a voluntary liquidation can be used, and we'll also be aware of some of the abuses which have taken place in the past. These have had to be addressed in reforms that took place during the last 30 years, and we'll see to what extent those reforms have succeeded in eliminating most, if not all, of the previous mischiefs and abuses. The alternative to voluntary liquidation, the compulsory route, does involve the court, and we should carefully study the circumstances in which the court's jurisdiction can be engaged. This involves a close understanding of the meaning of insolvency as legally defined as the inability of the company to pay its debts. And then we'll see which parties are eligible to use this inability to pay debts as a basis for seizing the court of a winding up petition. If the petition is heard and an order made for the winding up of the company, all kinds of consequences follow, which we shall map out week by week. We have to ask ourselves what happens to the directors and what happens to the employees, and what is the position of the creditors from that moment onwards. Crucial, of course, is the question of how the property of the company is to be treated and to whom its administration is to be trusted. This is in the form of an independent person known as the liquidator, who has to be an accredited insolvency practitioner these days. So we have to know what it is that qualifies somebody to be an insolvency practitioner and what are the regulatory oversights that are in place to ensure that the liquidator does a sound professional job. Once we have the procedure up and running, the two tracks, voluntary and compulsory, converge, and the process and the principles are largely identical. So we follow through the question of how the property of the company is collected and administered, how the claims of the various eligible creditors are dealt with and are admitted to proof, and how the dividend is calculated. We also need to see how certain types of creditors, such as secured creditors, can to some extent immunize themselves against the consequences of their debtor's failure. The two kinds of security, fixed and floating, are dealt with some detail, and we shall also see the impact of some major legal decisions by the courts in recent years, including the Privy Council decision in the Brumark case and the House of Lords decision in the Spectrum case, which has changed the landscape as far as the use of floating charge security is concerned. These cases have considerably changed the way in which the treatment of security by the law is now understood. Going on from the treatment of secured creditors, we encounter a number of other situations in which creditors can fare rather better than the average ordinary unsecured creditor. These include situations where set-off is available, and also where a trust device has been used to protect the interests of certain parties dealing with the company. We shall look at these, and we shall also look at ways in which the liquidator has powers that enable him to claw back property that the company has previously disposed of. So these avoidance powers are ways in which the ultimate dividends to creditors can be expanded, and these need to be carefully understood. We shall go on from there to look at the treatment of the directors when their past conduct comes to be measured against the law's expected standards of honesty and also of care and diligence in the management of the company's affairs. The law has a number of weapons available with which to scrutinize the past behavior of those who have been in charge of a failed company. These include making the director personally liable to compensate for losses caused by either fraudulent or wrongful trading, and also for general mishandling of company property. If things have been very seriously mishandled, it is possible that proceedings will be brought to bring about the disqualification of a director from being involved in the management of companies for up to 15 years going forward. We shall look at the circumstances in which that sanction can be brought to bear, and this also engages questions of human rights. And so we shall see how the gathering of evidence and the use of that evidence in proceedings against directors can at times engage the provisions of the European Convention on Human Rights and be transmitted through the Human Rights Act into active use in the court proceedings. At the conclusion of the course, we will study the way in which the property of the company is distributed among the various eligible parties to receive dividends, and we will then see how the ultimate fate of the company itself is to be dissolved so that it no longer exists as a legal person. That is the end of the story in most cases, but there is a little sting in the tail in that there can be life after death when the company has been buried and put in the grave under certain special circumstances. So the final minutes of the course, we will see how this resurrection can sometimes be brought about, and then we will conclude the course with a survey, and hopefully that will satisfy everybody's curiosity about how the liquidation of companies is conducted under English law. Thank you for watching this video. I hope that you will come along to the opening class in the next term in session ahead, and I look forward to seeing you there.